Welcome once again to Lehto's Law. Here's Steve Lehto.
Josh sent me a story out of the ABA Journal. I would have missed it otherwise because I'm not a subscriber. Thanks. Defendant doesn't automatically get new trial because judge nodded off. Top state court rules. That's right. A judge fell asleep during a man's trial and he appealed, and the court says, well, that's not necessarily grounds for reversal. A man convicted of assault and weapons charges is not automatically entitled to a new trial just because the judge fell asleep during a portion of testimony. This is from the Kansas Supreme Court. So this is a story going on in Kansas. The court ruled recently in the appeal that the man whose lawyers did not object and did not seek a mistrial when given the opportunity said that the isolated instance of nodding off does not amount to a structural error that affects the entire conduct of the trial and does not require automatic reversal. Now, they have a few things to say here. The trial judge admitted nodding off after the matter was raised by a juror. A juror asked, hey, didn't he fall asleep during the trial? I acknowledge myself, ladies and gentlemen, that I did nod off some, he told jurors. I doubt that I'm the first judge in America that's ever done that. No, you're not. But the question is, what do you do to fix it? Did something happen as a result of that? The judge told jurors that they are the triers of facts, and judges simply decide what evidence jurors will hear and what instructions they'll receive. The judge said he didn't think he missed ruling on any objections during the time that he was asleep. Hey, it's judge's nap time. Let's all testify quietly. The judge then stated that it is the defendant who is entitled to a fair trial and asked whether his lawyer wished to move for a mistrial, but the lawyer declined. So that might be a mistake right there. The defendant was sentenced to 43 months in prison after a conviction on charges of criminal possession of a firearm, aggravated assault, and felony criminal discharge of a firearm. The defendant is better known for a second case in which he was accused of stealing a wedding ring from the finger of a woman who lay dying after having an aneurysm at a Taco Bell, according to two newspapers which covered last week's Kansas Supreme Court opinion. The judge has since retired, according to the Wichita Eagle. The Kansas Supreme Court said the judge's inattention could have been worse. That could have been worse argument is not actually that helpful. A lot of things could have been worse. World War II could have been worse. Still pretty bad, though. This case does not present us with facts indicating a judge who slipped into any of the deeper phases of sleep, the Kansas Supreme Court said. There's no suggestion the trial judge was actually engaged in a full-blown nap on the bench. Just like a driver who feels the overwhelming physical need for sleep should immediately get off the road, a responsible judge charged with overseeing a criminal trial who feels a need for sleep and can no longer successfully put it off has the responsibility to call a halt to the proceedings. But just as not every dozing driver causes an accident, not every instance of a dozing judge must lead to an automatic reversal. The Kansas Supreme Court said there's no indication that the judge's inattention during his nodding off amounted to an abdication of his judicial responsibilities, which would have required a finding of structural error. Because there was no structural error, the next step is to consider whether the judge's sleepiness prejudiced the defendant's substantial rights. The Kansas Supreme Court said that the issue should now be examined on remand by an intermediate appeals court. So what they're going to say is, look, just because he fell asleep isn't an automatic gimme or a do-over. But we're going to ask another court to review what happened during the time of sleepyheads nodding off and visit the dreamland and see if anything happened during a time that does merit a reversal. So they're going to send it back for a look. They're just saying it's not an automatic, okay? The opinion also said the trial court erred when it accepted a stipulation to an element of the crime without getting a knowing involuntary trial waiver on the record. The opinion directed the appeals court to also consider that issue on remand. Don't have enough facts here to know whether that plays into it or not. But the sad part is two things. The first of which is, I've mentioned this before, that judges are held to a very high standard and they're required to hold themselves to a very high standard. And this standard is to avoid not just impropriety, but any appearance of impropriety. That is, you can't do anything bad and you can't do anything that looks bad. So if a juror actually asks and says, hey, the judge fell asleep. Did you fall asleep? And the judge goes, yeah, I did. There is so much wrong with that scenario. And don't get me wrong. I understand. People get sleepy. I've had a judge fall asleep in one of my trials. I'd like to think it wasn't my fault, But then again, it's not my job to keep the guy awake. And I've actually had a judge tell a courtroom, jury, everyone in it, actually say, from time to time, I lean back in my chair and close my eyes. He goes, I'm not sleeping. I'm merely resting my eyes. Now, there were occasions during that trial where I'm convinced the man was asleep. But every time we objected, he responded. Now, again, I don't know if he was responding in his sleep. I know people who talk in their sleep. For all I know, the judge was ruling in his sleep. But the point is that you'd object, other side would say something, the judge would make a ruling. Eyes closed, head back in the chair, resting his eyes. I'm convinced he was asleep. But, interestingly enough, if you reviewed the transcript of that trial, you would see the objection, you'd see the argument, you'd see his ruling. Nowhere did it say, oh, by the way, judge was asleep with a bunch of Z's to indicate sleeping judge. Okay? So, presumably, somebody can get to the bottom of when this judge fell asleep and what happened during the time of his sleep other than the rapid eye movements. Okay? Now, the Supreme Court is indicating they don't think he may have hit REM sleep. He may have been in that twilight sleep that you get before you hit full REM. I don't know. How they determined that, again, I don't know. But I don't have the full opinion in front of me. I just have the article written by Deborah Cassens-Weiss, which I appreciate, from the ABA Journal, sent to me by Josh. But again, the fact that the judge fell asleep during a trial and a juror noticed it, and then it apparently got put on the record and the judge said, yeah, I fell asleep. Sorry, shoot me. That's a problem because, like I said, it gives the appearance that the judge is not paying attention. He doesn't care about what's happening. And again, I don't want to sound like Oliver Wendell Douglas in Green Acres, and there's no Fife music playing right now. But a man on trial for a serious crime is facing prison time, and if he's not guilty and he shouldn't be found guilty, then he deserves a very, very good legal process. But likewise, even if he's guilty, we've determined that our Constitution guarantees everybody a full legal process, okay? Due process under the law, okay? And so the idea that you're going to go to court, jury, court reporter, attorneys, witnesses, maybe a gallery and some reporters, and a judge sleeping in the middle of it all. That's a problem. Now, again, the Supreme Court agrees with me on this one. The Kansas Supreme Court agrees with me on this one, that it's his job to recognize that he's too sleepy to do his job. He should halt the proceedings and do what everybody else does. I've worked in radio, overnight shifts from midnight to 6 a.m. About 4:30 in the morning, maybe 5 o'clock in the morning on a 6 a.m. shift. No one else is in the building. The building is dark except for one small room. The phones have gone dead hours earlier. I'm playing music and I'm having a hard time staying awake. I'm drinking Coke, not Diet Coke, regular straight up Coke. Caffeine and sugar, hoping that'll work. I'm standing up even though there's a stool in the studio I can sit on. Because I know if I sit down, I'm going to put my head like this, I could fall asleep with my hand up against my face. I don't want to do that. I can't do that because my song's going to end in 3 minutes and I got to say something and sound moderately coherent and hit another song. So what do? I stand up, I walk around, I jump in place, I scream and yell with the mic off, doing anything I can to keep my adrenaline flowing, to keep myself awake. So if a minimum wage disc jockey in Flint, Michigan in 1988 can keep himself awake at 4:30 in the morning or 5 o'clock in the morning, judge making six figures, you should be able to do it too, especially with all the eyes on you because it's your courtroom, okay? So the defendant does not automatically get a new trial because a judge nodded off, according to the Kansas Supreme Court. However, they will review it and take a look, see if he's entitled to one during the period of sleepyheads nodding off time. So nap time for the judge. There you go. Questions or comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thanks for watching Lehto's Law.